Hey everyone, this is our 2 cents on your dollars with the Strategic Insights Financial Planning Group crew, and we have Thomas Flores with Lara Flores Law Office. They specialize in business and estate planning, and we're super excited to have them here today. But before we get into that, we are not attorneys. This is not legal advice. We highly recommend you consult your own attorney.
Boo.
Guest speakers and their companies on this podcast are not affiliated with or endorsed by LPL Financial.
It may be Tomas.
Yes. It could be.
It could be.
Yeah.
So, Tomas, is our meter running?
Yeah, let me start the clock. Who
Typical
do I send the bill to?
That guy right there.
All right.
All bills directed to that guy.
No, Tomas, if you can just introduce yourself, a little bit of history, how long you've been an attorney, where do you practice, what area you like to specialize? I know I mentioned business and estate planning, but any specific areas in that? Floor is yours.
Yeah, well, thanks for having me, guys. Yeah, so I've been practicing for about 12 years now. Originally from McAllen and returned to practice down here. I worked with my father-in-law and I got to do a little bit of everything. And I found that I liked estate planning, probate, business, real estate most. So that's where my practice focuses on. So that's anything from wills and trusts to entities like LLCs or corporations, and even some real estate transactions.
Okay. You mentioned entities and LLCs. What are some common misconceptions that you hear about those subjects and or any other subjects?
So one of them is people are interested in setting up LLCs outside of Texas. So it's kind of like a...
Why would anyone want to leave Texas? Greatest country in this world.
Well, some of these other states, they try and entice people to come and open up entities over there, like in Nevada, Wyoming, and they tout their asset protection laws. They say they're very pro owner and make it harder for creditors to collect. So a lot of people, I don't want to say fall for that, but they're enticed by that, and so they want to go and set up these entities in Delaware and Nevada, and they think it's going to give them more protection. But the problem there is that LLC ownership is a personal property that belongs wherever you are. So if you're in Texas, even though you have a Nevada LLC, that's still personal property that's here in Texas. So Texas law is going to apply to that if someone sues you. Not to mention that if you did get sued and you wanted that lawsuit to be in Nevada or Delaware, that means you're going to go over there too. And you're going to have to hire an attorney out of state, which is going to be more of an inconvenience for you. So that's a common one that I see.
So LLCs are for asset protection, not tax purposes?
I mean, they could be. A lot of people assume, people who are sole proprietors, they think that setting up an LLC is going to give them all these tax benefits. Typically not. You can usually take the same deductions and expense out the same stuff as a sole proprietor as you would as a single member LLC.
Do y'all get that a lot? When people think that?
Yeah, I think they get it a lot from their tax preparer. Create this entity, start a business. I've never understand that notion of, hey, just start a random business, take a bunch of deductions. It doesn't matter that you're not successful, but hey, at
You
least
save
you
some
can
money
take
on
the
deductions. And you're not paying taxes.
Right. And I always sarcastically make a comment. Usually when you start a business, you want to be successful. And I'd rather be in the top bracket than make no money. But they kind of almost forget that because they're just so focused on getting deductions,
The tax savings.
The tax savings.
Mm-hmm.
Yeah.
Yeah.
Yeah, I always tell people that entities are first and foremost asset protection. They can be used for tax benefits, but the primary purpose of them is asset protection.
It's kind of in the name, isn't it?
Yeah, limited liability.
Is that what LLC stands for?
You heard it here first.
Learn something new every day.
Is there? Would you consider estate planning and entity setups the same thing?
Well, they're related because entities are definitely a part of an estate plan, and they need to be integrated. And so estate planning, we're trying to prepare for leaving an inheritance, right? Whereas entities, it's for asset protection. But the idea with that is that you want to protect the wealth that you've built so that you can leave it to the next generation. So that's how they kind of work hand in hand.
How often are you reviewing these entities that get created and have been created 30 years ago?
So when we do have clients that come in to do their estate planning, if they already have entities, which is probably more common, that they already have entities because they're business owners and that was their priority, right? They want to protect themselves from the liability of the business that they own. Then when the business gets successful, starts to be worth something, then after the fact, they start thinking about estate planning. So in those situations, we definitely review their entities to make sure they're set up properly and that they've been updated, and then of course work to integrate it into the estate plan.
What would be like a good rule of thumb for like business owners? Like how often should they be reviewing these?
I mean, at least annually, I would say.
I think one of the most common comments we get from clients is they don't know who should be leading the spear. In your perfect world, you've got advisors, CPAs, attorneys, and they all want to do good for their clients. But what we found is there's a lack of collaboration for whatever reason. With your experience, when you're working with a client to really get it right and it's efficient, what is the perfect scenario in your mind when collaborating with other professionals? How do you picture it, and how would you like it?
So I usually find that the financial advisor is a person who's closer to the client, has more frequent interaction with them. So they're typically more like the quarterback, if you will, bringing in the other professionals. But definitely if there's something that comes up in between their regular meetings with the client, it's always ideal if all three of those people can get together. So the best planning for the client is going to be when we've got financial advisor, attorney, CPA, literally in the same room. If we can do that, talking about it, looking at it from different angles.
You don't prefer virtual?
Virtual works fine, and it's nice everyone's gotten comfortable with that. But kind of just doing like a round table, everybody pitches in their ideas and kind of kicks things around. That's great if we could do that.
Alexis loves virtual because he doesn't have to wear pants if he doesn't need to.
I've sat in some of those meetings before with the attorney and CPA, and sometimes it gets a little interesting just having those conversations because not everybody sees eye to eye, and it's also kind of funny when we see the spouses kind of going in different directions. They're like, I just kind of want to scoot away.
Yeah.
We probably we dove right into the deep end, and that's my fault. What is estate planning?
So with estate planning, we're preparing for two scenarios: death and disability. So with death, you know the old saying, "You can't take it with you." You've got to plan for where your assets are going to go when you die. And with disability, we're talking about during life. If you lose capacity, or just for convenience sake, you're just not able to get around and make decisions, who has legal authority to make those decisions for you? And so we put in place legal documentation to carry out those wishes and make sure they're enforceable.
What kind of wishes? Like just where your assets go, or is there more to it than that?
So yeah, typically, I mean, the first thing people think of with estate planning is, who's going to get my things? But there are other considerations, like if you have minor children, who would be a guardian for those children? If someone needs to receive their inheritance in a trust because you want to exercise some control over it, who's going to be in control of that trust, and at what point those people will get access to that money? For disability planning, there's financial power of attorney, medical power of attorney, but also a directive to physicians. So if you're in a scenario where you're on artificial life support and that's the only way you continue to be alive, you make a decision on whether or not you want to continue in that way or you want to be allowed to pass naturally. So some of those issues are dealt with in the estate planning.
Does everyone need a trust? Because I feel like that's the one I get all the time. Every time I get questions from clients, it's I need a trust. Everyone needs a trust.
No, everyone doesn't need a trust. Some people need a trust, but not everyone, because we can definitely accomplish the same goal without a trust. So it really is. Everybody hates to get the answer. It depends.
Yeah.
But everyone's scenario is different, and so depending on what kind of assets we're transferring, depending on who they're being transferred to, and how you want them to be transferred, you may need a trust. But not everyone does.
Okay. We're trying to get there later, but we're already here.
You went there.
You went there. What is the difference between will and trust?
So fundamentally, they're the same in the sense that you state who gets what and who's in charge of carrying that out. The biggest difference is that the will requires approval from the court to be activated and enforced. And that's a process we call probate. So the will has to be approved. The person you appoint to be in charge has to be also approved and appointed by the court. Whereas with the trust, all of that happens without any court approval. The court doesn't need to accept or approve your trust. It doesn't have to appoint your trustee. There's no need to go to court at all. So what that ends up doing is saving you a lot of time, so you don't have to go to court, and money, because again, you don't have to hire an attorney to go to court. And for a will, you have to hire an attorney. You can't represent yourself. So that's one of the main benefits of the differences between a will and trust.
So what is that probate process like time-wise?
Time-wise, I would say you're looking at 6 to 9 months is kind of an average, right? And things could happen a little faster or things could take longer. And there definitely are some cases that take years. And so, it just depends.
Oh no, I was gonna say we don't have a ton of probate judges down here either, so that doesn't help the length of time.
Yeah, in our county we have one probate court, and especially during the pandemic, they just got slammed, and the cases were taking over a year, 2 years to get resolved. So yeah, you never know if there's going to be a lot of cases when you need to go to court. It might take longer.
In our careers, it seems that probate is a dirty word, but are there cases where it's actually a good thing to go to probate?
So if you like the idea of court supervision, or you need some structure to the estate, then maybe probate can be good, right? So sometimes if we've got a lot of heirs or we've got a lot of conflict between the heirs, having the probate judge as a sort of referee, if you will, can help. Or if there's somebody that you don't trust to handle things on their own outside of court, maybe you'd rather that they have some supervision from the court.
What are the costs typically surrounding something like that? Because that's also another thing that gets brought up is, the costs of generating and putting together a trust in comparison to the costs of probating the estate.
So the way I like to explain it to clients is that with trust, you're kind of front loading the expense. You pay it now rather than later. So trust will be more expensive to set up now, but in the long run, it's going to be less expensive than going to probate court. So I would say that, setting up a trust now may cost as much as probate or a little less, but especially if you have a married couple where we're doing joint trusts, you're avoiding probate twice over, and you're avoiding guardianships and other potential issues in court. So in the long run, I typically find that the trust is more efficient cost-wise.
Should that trust be, you mentioned it should be, you're front loading it now, but we see trusts all the time created by the will. And so a question we usually get is, why wasn't it just created now versus the will creating it?
Yeah, you do see what we call testamentary trusts that are created in the will.
Yeah.
So you have to go to probate in order to set up the trust, which kind of seems like it defeats the purpose. Some people like that court supervision, so they want people to go through probate. There's some rare instances where a trust has to be set up through probate court, where you're dealing with Medicaid or special needs. You can't do a living trust; like you have to do a testamentary trust. But generally speaking, it's going to be an inefficient way to set up a trust.
And there's some issues too with regards to privacy. Isn't there something in regards to information?
Yeah, definitely. So one of the benefits of the trust is that it's a private document. You don't have to record it anywhere. You don't give it to the court. You don't file it in the deed records. It stays private. Whereas a will that goes through probate court, it's public record, which means that your trust is also public record. So if you've got a large estate and you're leaving a significant amount of money to your heirs, that's going to be public knowledge. And there are a lot of companies that go and scrape data from the probate courts to try and solicit these heirs. I just saw it myself this week when I was at the probate court. Some lady went up to the clerk and asked for a list of estates being probated.
Wow.
Presumably to send them like spam mail about buying their houses or paying for their interest in the estate. And so, yeah.
Is that legal?
It is, because it's a public record. You can go, the clerks don't have such a list, but anyone can go on the public website and look through all the estates, get people's addresses from there, and send them stuff. And all of my clients have that problem. They start getting letters in the mail after we file their application, offering to buy their house from them, or pay them. I'll give you an advance on your inheritance, and you assign it to me.
Wow.
They should just set up fish bowls.
Instead, yeah.
Wow.
Right at the clerk desk.
Do y'all ever get this? I don't need to put a beneficiary on there because I took care of it with my will.
Never
Yes.
heard of it.
That was sarcasm.
Yeah.
What say you, sir?
I think beneficiary designations are the most powerful estate planning tool there is. It costs nothing to do, and it completely avoids probate. And you don't even need an attorney to do it. So it's
Don't even need an advisor to do it.
so yeah. I mean, it's definitely an underutilized tool that people should make sure that they take advantage of if they can.
So we've always wondered, what if they say different things, the will and the beneficiary designation?
The beneficiary designation controls. So whatever you have named there on that account, that's who's getting that account.
So have you ever run into a situation where a beneficiary designation kind of ruined the estate plans because they said two different things?
Yeah, if people forget to update the beneficiaries after doing estate planning, it can definitely create some problems. And that could just be that they, name somebody who's now deceased, right? They might have named a spouse who's since died, or another family member who's died. So there's no longer a beneficiary on that account. That
Or
happens.
an ex.
Or an ex-spouse. That happens. And there's some solutions for that, but it's not without having to do some work and costing you some money to fix. But updating the beneficiaries is a simple fix. So.
We've noticed with some companies, if the spouse is not the beneficiary, the non-beneficiary spouse has to sign off. But in some companies, they don't have to do that. Where's that coming from? Why is such a difference?
So the reason for that is here in Texas, we have community property. So even if an account is solely in the name of one of the spouses, the other spouse still has an interest if it's community property. So they would have a claim to half of that account. So if one spouse is going to give that account to someone not their spouse, that's why these companies want the other spouse to sign off on it. And even if that's not the case, it's just, a safe practice to make sure that both of them are on board, because it can happen that, and I've seen it happen, where one person gives their life insurance to a son or a daughter, and probably from a prior marriage, this new spouse has a claim against that.
Right. So it's each company's interpretation of Texas law regarding community property.
Yes.
Okay. But it's not a requirement of Texas law.
No.
Okay.
Since we're talking about beneficiary designations, what about minors as beneficiaries?
Yeah, minors can be problematic because minors can't own property outright. So if you've got a minor as a beneficiary, that bank, that life insurance company, they're not going to send a check to a minor. And what they'll require is for someone to be appointed their legal guardian. And this can throw some clients off if we have, for example, a grandparent who names a grandchild as a beneficiary who's a minor. The biological parents of that minor cannot just collect on their behalf. Even though they're their parents, they have to go to court to be appointed their legal guardian. And that's an expensive process. A lot of follow-up work is involved in that as well. So, the simple fix is to either name a custodian for that child as a beneficiary or a trust for the child.
Time frame?
Well, I mean, with the guardianship, there's maybe two phases to it. First is getting appointed, and that's probably also around 6 to 9 months. But then that guardian is there for the child until they become an adult. So, for however many years that is until they reach 18, they're going to be reporting to the court on an annual basis. And and then especially if there's multiple children as beneficiaries, it can get to be expensive.
You have to do it during football season too. It becomes really inconvenient.
I can imagine.
Those Sundays.
I can imagine.
That sounded like experience right there.
You've been to court on Sunday?
At home.
Well, you mentioned custodian and legal guardian. Where are those actually created? In the will? At the institution?
So a custodian would be created at the time of making the designation.
Okay.
You're taking advantage of a law that we have in Texas where you can name somebody as custodian for a minor. And that's just a matter of titling the account or the beneficiary correctly. Whereas a legal guardian, that has to be done by the court. Legal guardian can only be appointed by the court. And you can identify who you want to be the guardian ahead of time, like in your will or as a separate document, your preference. So you say, if my child needs a guardian, this is who I want to be appointed. But that person still has to go to court and apply to be appointed.
I see.
So it sounds like we're getting some free advice. I'm going to take advantage of it. So you mentioned...
You haven't done this already, I see.
No, I mean, we do it all the time. You mentioned the language, taking advantage of a Texas law.
Yeah.
Naming a custodian. What is that language, if you can tell us that?
So the law is the Uniform Transfer to Minors Act. So sometimes people call them UTMA accounts. But you would name, parent as custodian for child under the Uniform Transfers to Minor Act.
Okay.
So if you name it that way, you could take advantage of that law.
Okay, so speaking of alternative pronunciations, settle the debate. How do you say? I'm not gonna even say it. How do you pronounce the term PER space STIRPES? What's the proper?
Can you say that in a sentence, please?
Oh,
right.
Language of origin.
Per stirpes? Is that what
Okay,
you-
good.
Yeah.
That's the way I say it. Yeah.
Yeah, per
Is that
stirpes.
Latin?
Yes,
Has to be.
by roots.
By the roots.
So then that's probably not the way to say it. Huh? Per stirpes. Anyway.
Definitely not.
Per stirpes.
Yeah, so that's dealing with who your descendants are. How do we divide up an inheritance when somebody at one of the first levels dies? So typically, that person, if they have children of their own, will take their share. So we've got 4 kids, one of them's dead, then that deceased child's 1/4 would be divided up by however many children they have.
Is that language that needs to be like in there, or is it just automatically that's just how it goes?
It's typically written into the will or the trust.
Is there? I'm thinking beneficiary designations. If there is no indication that it is per stirpes, is there?
I found that varies by institution, but typically what I see is that it's just equal shares, whoever's there.
Right.
And I don't know that they even get to that point of if one of those beneficiaries dies, they're not going to go looking for that person's descendants. They're just going to say, you know what, there was 4 people named here, one of them's dead, we're giving it to the 3. And that's one of the limitations of beneficiary designations. They're very powerful, but they're also very simple. So you can't use it for everything. If you want to have that kind of detail and exercise more control, then that's where trust comes into play. Because a beneficiary designation is great for outright gifts. These 2 people are beneficiaries. The bank cuts a check 50-50 to each of them. It's theirs. If you don't want those people to just get checks made out to them, or $1 million life insurance policy, you send it, here's $1 million check, then that's where I recommend a trust. With a trust, you can put restrictions, you can put instructions, qualifications, things like that. You can get more detailed about what's done with the money.
Typically, who's in charge of executing those wishes when it comes to the trust language, right? Because the individuals who originally set those up are no longer here. So who are those people that now are responsible for making sure that does happen?
So that person would be the trustee. So with the trust, you have 3 parties: the grantors that set up the trust, you have the trustee who manages it, and then you have the beneficiaries who that property is held for. And so if you think of it like an analogy of a bus, right? The trust is the bus, the trustee is the driver, and then the beneficiaries are the passengers. So if the initial trustees die, no more driver,
Right.
Then a successor trustee is typically named in the document. New driver jumps in the car and the bus and keeps driving. And so if you have named successor trustees, we kind of go down that line. If no one is named, or all the people who are named are no longer available, then the court can appoint someone. And you leave instructions. Okay, at this point, stop the bus, let everybody off, and or keep going for as long as you can.
Some individuals I know have difficulty naming trustees, just because of family dynamic, things like that. They don't want to put responsibilities on some individuals. They don't want some inter-family turmoil, adding that responsibility. Are there alternatives to naming an individual as a trustee, or a couple individuals as trustees?
Yeah, definitely. In those scenarios, we recommend a corporate trustee. It's either a trust company or a bank that serves as trustee professionals. And it's definitely a good option where you don't have somebody that you trust, or somebody who's just, they're not up for the task. Or maybe there would be a conflict in naming someone. This is a neutral, third party. It's also a professional who knows what they're doing. And if they do mess up, they're going to be good for it, because they're probably, a successful company that's been around for a long time. You should choose someone like that. And so it's definitely an option to consider in those scenarios.
No conflict of interest as well, too.
Yeah, they have no conflict with any of the beneficiaries. They're neutral. They're more likely to follow the instructions in the trust because they know that they have a fiduciary duty. They don't want to get in trouble for that. And they didn't know the people who set up the trust, so they're not going to kind of interject with their own opinions. They just have to read what's there and follow it.
So it sounds like people don't always listen to what they're supposed to do.
Yeah, that can happen. Some people can kind of maybe go astray of the rules and bend them if they think, well, it's not fair to me. You run that risk. I mean, and then of course there's always a risk that some people will mismanage the trust assets, either intentionally or unintentionally. Maybe they're just not sophisticated in dealing with those kind of assets. Oh, and then all the way to people who just steal.
Do you ever feel like you need to interject and be like, that's not a good choice? That's not a good choice.
Well, I mean, my role is just to explain to them what the instructions are in the trust and that they're supposed to follow that. But then if people don't, that's when beneficiaries hire their own lawyers and they sue trustees and
Okay. Can you clear up this common misconception? This inheritance or gift is taxable. That's the way it's presented.
Yeah, and I think
y'all hear clients say that?
Yes.
Yeah.
so. There's two sides to that: receiving the gift and giving the gift. So in Texas, we don't have an inheritance tax to receive an inheritance, but there is a federal estate tax to give an inheritance, and so there's an exemption amount that up to that point there's no tax owed, and most people will fall under that, but there's not going to be any tax for receiving the gift.
Yeah. I think sometimes people get it confused with federal income tax and estate tax.
Yeah.
Yeah. So gifts are not income taxable to you, to then the person receiving them. Is that correct? Yeah.
Yeah.
Okay.
Not
Just wanted
income.
Just wanted to clarify.
No, yeah. It's a big one.
Most beneficiary designations, it goes to a person. If the client wants to give it to a nonprofit, do you recommend, if possible, they still do it through a beneficiary designation or through a will or through a trust?
So they can do it through beneficiary designation. The difficult part is, how do you make that organization aware of the gift and get it to them?
Okay.
So when you name individuals, they'll take it upon themselves to go and file the
They'll
claim
find
forms.
You. They know where you are.
Yeah, they'll be knocking at your door for their check.
Right.
But a charity, how are they going to know? So what I do recommend is, if clients do that, they notify that organization at the time of making the designation,
Okay.
so that they can be aware, at least, that there's an expectation of an inheritance there for them, or a gift. Yeah.
Is that the most efficient way to give to a nonprofit?
Well, I mean, there could be, if you want to have some more oversight over how that's done, the trust would be a good option for that, because you have a trustee who would take care of notifying the charity, getting the gift to them, and then there could be other types of trusts, like charitable trusts, that could take advantage of some tax planning.
Do you ever recommend otherwise, or what?
Well, I know we've had this conversation just about people asking or having that charitable inclination, right? And so as we've come across, there's people kind of give us some of these scenarios where they want to do X, Y, Z, and a lot of times it's always at death. And what we have found is sometimes, most of the time, almost all the time, there's better ways for them to do it while they're alive, where they can actually receive some benefits of it. And that way they can still accomplish what they want to, and yet it gets a little less, I guess, expensive having to set up trust and different things like that.
Yeah, I mean, giving during life can be a great alternative. You get to see the gift enjoyed and received. You get to make sure it's given to the right person, and that applies not just to charities but to individuals. Grandchildren or children, friends, because sometimes things have a way of walking off when people die and getting lost, and they don't make their way to the intended beneficiaries. But if you give it while you're alive, you know that that's not going to happen.
Yeah.
My first thought is they get to save money on taxes, right? So that's my first
Yeah, I
thought.
mean, they have that benefit if they're giving to a charity. They could take benefit, take advantage of that for offsetting taxes now.
That's not the only reason why you give, Alexis.
I understand that, but there are some people that's the only reason why they give. And for some of the nonprofits
Yes,
that I serve
other
on, I'll
people.
take that money all day, every day.
Nobody in this room,
No, no,
and none of our viewers.
none.
I
Hi,
got
Mom.
I gotta know TODs on joint accounts. Yay, nay.
What TOD?
Oh yes. Well,
Is it Latin?
Pig Latin.
Can you use it in a sentence?
So you're asking whether it's a good idea to do a TO, or whether
Is
you
it
can
nec-
do it.
yes.
All the above.
All the above. Expand
So
on it.
yeah, there's several different ways to set up the account. It could just be a joint account where each person, owns the account 50-50. And technically, if one of those people dies, you have to probate their estate, and their half of the account is going to go through probate. Then you have joint with rights to survivorship, where if one person dies, the survivor keeps the account. And then there would be joint with rights to survivorship and TOD. So rights to survivorship will avoid any probate for the first death, but not the second. Rights to survivorship and a TOD will also avoid probate on the second death.
And what's a TOD?
Transfer on death.
So do
Todd.
you do it at the beginning where they're both alive, or you just do it after there's just one?
Well, it depends, because you would need to set it. Ideally, you set it up while they're both alive. Because if you don't and one of them dies, you may not be able to do it for the whole account.
Since we're talking about joint accounts, can you talk about the idea of naming somebody as an account holder in a joint account and it being a gift? Or is that technically considered a gift?
Oh, I know what you're talking about. You're talking about where like
So I have
a
some-
parent has a
right.
kid. I've seen that where a
yeah.
parent has a kid on their bank account.
Mm-hmm.
So I think, if they end up receiving that account, then yeah, it would be a gift. It's something that they're going to receive without having paid for. So that's going to be a gift. I don't know if when they're named or added, the gift is made at that time. But certainly if the person dies and then that child ends up with the money,
Yeah.
that would be a gift.
But that's a gift at death, so it wouldn't be a taxable gift. Oh no, never mind. Okay.
Would there be a cost basis step up?
So generally, there's going to be a step up in basis when the person dies. If there's joint ownership, that's a little bit different, but it just depends again how the account is set up.
I think is it one of those where it's half gets a step up?
Oh, we're going back to some Series 7 questions. Let's go.
Do you have your book?
Let me get my manual. Keep in my front pocket here.
Any other last parting words or strategies that you want to share?
Well, I had a real quick question. Because bringing up Todd's, deed transfers. There's some newer efficient ways to transfer deeds on houses.
Ladybird.
Is that correct?
Yeah. So going back to Alexis's question about does everyone need a trust, these transfer on death deeds where you name a beneficiary for your real estate is a way to transfer without using a trust. And so before we were able to do transfer on death deeds in Texas, we would do ladybird deeds, which is kind of a workaround, something that people put together. But the transfer on death deed is something that's stated in the law. It's based in the statutes, and so yeah, that's a very efficient way to transfer your real estate. So for most people who just have financial accounts and real estate, you could use beneficiary designations across the board, transfer everything without going through court or needing a trust.
I feel like I've seen it used for healthcare purposes, right? In our area where we have a lot of individuals receiving benefits and they're always scared about their house getting leaned on. Can you explain a little bit more as why that's useful?
Yeah, so if you receive Medicaid benefits, the state will try to recoup some of what they paid on your behalf. And fortunately, in Texas, they can only do that through the probate process. So if you could transfer your home outside of probate without having to go through that, then you don't give them an opportunity to collect
grab it.
against that. And so the transfer on death deed will help accomplish that.
The true tot. The true tot.
Okay, so I'm a 55-year-old person, got $1 million saved up, very simple. My primary homestead, maybe a rental property, 2 kids, both grown out of the house, married. Pretty simple. What is the go-to basic estate planning that I should do?
So one of the considerations there is, do you want to or need to control how that's transferred? So we could do a beneficiary based plan for someone like that if they're comfortable with their kids getting everything outright, and if they're comfortable with their kids becoming joint owners of the property, the rental property. That can be an issue, right? You know, having co-owners of any asset is like making them partners in an investment. And in my experience, most people, you know, they don't work well like that. And so a solution could be a trust to liquidate assets and split it that way. Or if you want more control, you don't want anybody to receive their inheritance just outright. Maybe it's a trust for the kids. So I think that would be the factor there.
Awesome, man. We appreciate you being here. Hopefully next time we have you on, we'll go even deeper on these niche strategies.
Yep.
Yeah.
We didn't even touch base on FLP.
Oh,
I'm
goodness.
planting the seed.
Uh-oh.
No, but we really do appreciate you being here.
All right. Thanks for having
Thank
me,
you,
guys.
Tommy.
Yeah, thanks, Tommy. Appreciate
Thank
it.
you all. That's our 2 cents on your dollars.
The opinions voiced in this podcast are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which strategies or investments may be suitable for you, consult the appropriate qualified professional prior to making a decision. There is no assurance that the techniques and strategies discussed are suitable for all investors or will yield positive outcomes. The purchase of certain securities may be required to effect some of the strategies. Investing involves risks, including possible loss of principal.